We're very honored to have a very distinguished speaker for the lunch to talk to us about a judicial perspective on the issues that we're talking about today. Judge Paul Grewal is the U.S. Magistrate Judge for the Northern District of California. He's been in the news frequently in the past year in a number of very high-profile cases. He's a member of the Northern District's Technology and Patent Local Rules Committee. He's also co-chair of the Federal Circuit Bar Association Judges Committee and co-chair of the Federal Courts Committee of the Santa Clara County Bar Association. Before his appointment, Judge Grewal was a partner at Howry and at Day Cabraser, where he served on the firm's management committee. His practice was focused on intellectual property trials and appeals. He's the proud holder of a registration to practice before the U.S. Patent and Trademark Office, and he's also tried patent cases from Marshall, Texas to Wilmington, Delaware, and he's argued patent, copyright, and trademark appeals in circuit courts, including the U.S. Court of Appeals for the Federal Circuit. Before entering private practice, Judge Grewal served as a law clerk to Federal Circuit Court Judge Arthur Gajara and U.S. District Court Judge Sam Bell. He received his undergraduate degree from MIT and his law degree from the University of Chicago. We are delighted that Judge Grewal accepted our invitation to speak. There is perhaps no better person at the epicenter of technology today to give the judicial perspective. And he told me that he is a jury deliberating, so I don't want to spend more time on the introduction. We're anxious to get started. He does want to allow ample time for questions, assuming that the jury doesn't come back early. So, Judge Grewal?
Good afternoon. Well, I suppose if I'm at the epicenter, that doesn't bode very well for my long-term future. I appreciate that very warm introduction. And I also want to wish a belated Happy Father's Day to all the fathers in the audience. Are there any fathers out there besides me? I hope you had a great Sunday. I hope you had a slightly better Sunday than I did, because as it turns out in the Grewal household, there's not yet a full appreciation of what every father truly wants on Father's Day, which is, of course, to be left alone. I love my children, I truly do, but they have not yet grasped that concept that what a father wants more than nothing else is perhaps 30 or 60 minutes of sleep. And so I hope you all fared a little better than I did. Once my kids got me up at 6:15 instead of 5:45, and after they gave me their presents and all that good stuff, we had to figure out what to do. And so, being a good, responsible parent that I am, I immediately plopped on the couch and popped on the television with them. And true story, we were flipping around the channels, and I stumbled across probably my favorite cartoon of all time as a child. Can anybody guess what that is? Scooby-Doo. Fantastic insight from row number 3. Now, I don't know if everyone in this room has seen Scooby-Doo, but I suspect most of you at least caught 1 or 2 episodes. Is there anybody in the room who has never seen an episode of the Hanna-Barbera classic Scooby-Doo? Raise your hand, fess up. Oh, Sasha, come on. Really? 90+% of this room is familiar with the concept, so I think some of my comments will perhaps resonate in a certain way. I should confess at the very beginning that I watched a lot of television as a child, and in particular a lot of cartoons. Both my parents worked a fair amount, and apparently there wasn't much thought given to a more productive use of my time while they were doing other things. It did seem as if they were running an experiment as to what would happen if you were to expose your child to as much television programming as possible. And the answer appears to be that he will grow up to be a United States Magistrate Judge. So take that to heart when you're figuring out what to do with your own children and their screen time. Well, I will confess, and this is an absolutely true story, I ended up watching not 1, not 2, but perhaps 5 or 6 episodes of Scooby-Doo on Sunday morning with my children beside me. And as I was reminiscing about the episodes, I was reminded, of course, from time to time, that I needed to think about this speech today and what I would say to you all today about best practices in federal court litigation. And it became clear to me that there were indeed many lessons one could learn from Scooby-Doo about how to practice and practice well in the federal courts. And so I hope to share with you a few of those insights over the course of the next several minutes. Quick aside for those of you who are true culture buffs, does anybody know who happened to pass away yesterday? Casey Kasem. And does everybody understand the relationship of Casey Kasem to Scooby-Doo? Zoinks! Exactly right. Shaggy. Casey Kasem, of course, the renowned voice of American Top 40, something that I spent the rest of my weekends as a child listening to and focusing, passed away. I believe it was either yesterday or the day before. And, of course, Mr. Kasem was the distinctive voice of, I think, the greatest character on television, certainly on Scooby-Doo, which was Shaggy. So in memory of Casey Kasem, and in light of how I chose to spend the better part of my Sunday morning, let me offer you a few insights, if I could, on the federal court system and litigation in the U.S. district courts in particular, based on my experience with Scooby-Doo. Now, Casey Kasem, of course, counted down the top 40 hits every Sunday. We don't have that kind of time, so I'm going to truncate this conversation just a little bit and focus on the top 5. I understand that most of you have seen Scooby-Doo, but there are some who have not. And for those of you who perhaps haven't seen it as recently as I have, let me just refresh you on the basic premise of this serial drama. The basics were pretty much the same in each and every episode. You had Fred, the handsome blonde leader, leading the gang on one mystery adventure or another. Daphne was the dashing and somewhat dim-witted sidekick who nevertheless found a way to add value in the investigation. You had Velma. Everybody remember Velma? My glasses. I can't find my glasses. Remember Velma? The bespectacled genius who ended up putting together all these different clues. And of course you had Scooby and Shaggy doing something or another, stumbling into a clue that brought the whole thing together. Every week this group of kids, teenagers in this 1970s cartoon, would drive around to various cemeteries and mansions, and they would stumble into some kind of adventure or another. They'd split up to search for clues, eventually put it all together, and by the end of the episode, they'd end up capturing the monster of the week and revealing him or her for who they happened to be. Well, in the course or over the course of all these different adventures, there were, I think, a number of important lessons that bear relevance to the conversations we're having today, and not only today, but over the course of the next months and weeks, I think it's fair to say, and even years, as many issues in technology litigation play out. The first lesson I want to urge to you all from Scooby-Doo is that there are no shortcuts to success. And what do I mean by this? Well, as I said, every episode of Scooby-Doo involves some kind of monster who ended up being some kind of conniving adult looking to get away with some kind of violation of what, in my world, today we would call Title 18 of the United States Code, which is, right, conspiracy, wire fraud, some kind of possession with intent to distribute. So the basics were pretty much the same from week to week. But the important lesson that I think one can draw from the outcome of just about each and every episode is that whether it was a bank robber trying to hide his loot in a swamp or some kind of professor looking to pull some scheme or scam to rob a gravesite of its jewels, in the end, the plot is revealed and the bad guy ends up in jail. Now, what on earth does this have to do with anything involving the federal courts, American litigation, and certainly best practices? Well, I would suggest this. One of the most important things I do as a U.S. magistrate judge is I review applications for search warrants. Now, perhaps some of you in this room have some familiarity with this process or concept, but let me shed a little bit of light on it for those of you who don't. In the Silicon Valley courthouse in which I sit, which is on 1st Street in downtown San Jose, On any given day, we have visits from agents of the Federal Bureau of Investigation, the IRS, the DEA, and agencies none of you have ever even heard about. And why do those agents come looking to visit with me or my colleagues? Well, they're looking for warrants, and they're looking for warrants in large part to search data. I would have to say that the percentage or fraction of warrant applications that I review involving the classics, as we refer to them in the federal courts, stash houses, hideouts, things of that nature, very small, very small. In fact, the vast majority of the search warrant applications that I review have to do with servers, have to do with Gmail accounts, have to do with Facebook profiles. And I think it's important for this audience to appreciate that that experience, I think, permeates the life and the daily work of every judge in this district and in most districts across the country. And in that experience and work, we have come to see that in the vast majority of cases, you can't get away with very much without being noticed. We see elaborate schemes being revealed in texting trails. We see incredibly sophisticated operations being managed globally now through the use of these different accounts that many of you are responsible for managing and perhaps even litigating. The bottom line, though, is that no matter how clever, how elaborate the scheme, I have to say, as someone who reads a lot of affidavits from a lot of agents of the FBI, in the end, they will find you. And so I suggest to you all, in thinking about litigation strategy and in trying to evaluate risk and calculate risk for your clients and for your partners, keep in mind and bear in mind that if there is indeed malfeasance, they will find you. And I think it's important to always remember that and not simply hope for the best and do a little more than that. The second lesson I would like to suggest to you from my Sunday morning experience with Scooby-Doo is that it always pays to negotiate. What do I mean by this? Does anybody remember how Fred or Shaggy or Daphne would get Scooby to do something that he really didn't want to do? How did he do it? Scooby snacks. Yes, exactly. When all else fails, the kids reach for the bag of Scooby snacks. And invariably, Scooby negotiates some kind of deal. It's never enough to just give Scooby one snack. You have to give Scooby multiple snacks. But the important lesson to keep in mind from this is that in every case, there was a reservation price, right? There was a deal to be had. And I want to just suggest to you all that over the course of your experience with federal litigation, I think all too often parties lose sight of the fact that there is always a deal to be had. And in fact, the best companies, the most successful companies that I have the experience and pleasure of working with, understand this in any number of different ways. I speak to you from my experience in managing settlement conferences for cases big and small, but in large part for cases involving technology like the type of technology you and your clients work on. One of the most important responsibilities a magistrate judge has in any district is in trying to get cases settled for other judges. And so that takes up roughly 25 to 33% of my time, a good chunk of it. And when I observe parties coming to the typical settlement conference in federal district court, more often than not, here's what I tend to see. And you can tell me if this rings true to your experience. Lead counsel is there, occupying the first seat next to the judge. There may be lawyers from inside the company also present, or there may not be, depending on the size of the company. There may be individuals who own P&L responsibility for the products at issue, or there may not be. My point, though, is that in the vast majority of cases, trial counsel is taking the lead. And we all know how critical it is to have trial counsel, right? And yet, in my limited experience, to be fair, trial counsel has a very different job than the job that needs to get done at a settlement conference. The very best can, of course, perform each of these roles. But I would just suggest to you that more often than not, too little attention and focus is paid on who needs to be there in order to get the case settled, not who needs to be there in order to persuade the judge that your side or your party is right. There's a difference. There's a huge difference between being right and getting the case settled. And too often I see that difference ignored. I also, I think, tend to see more often than not companies, particularly in the industries that we're here to talk about today, coming in with almost little or no thought paid to the strategy of how you get to resolution. And what do I mean by that? Well, I don't think it's much of a settlement conference strategy to come in and sit down and tell the judge something like, well, all you need to do, judge, is go over to the other side and tell them why they're wrong. That's not much of a strategy, because I understand that each side feels very confident in its positions. I get that. But the very best companies, I think it's fair to say, come in with a more creative approach to getting to that resolution and a way of persuading the other side that there's an upside to resolving the case. It is astounding to me how much energy and effort is put into the typical settlement conference in federal district court litigation. If you look at the briefing, if you look at the mocking that clearly is taking place in the largest cases, if you look at the presentations and the quality of the presentations, it's not for lack of resources that these cases are difficult to settle, but the approach I would offer or suggest should be much more one of a sales meeting and less of one of a litigation event, right? I mean, you have a trial judge for a reason, and that trial judge and a jury, if necessary, will do their job if necessary. But in the settlement conference, I think the best companies, it's fair to say, understand they're there for a different reason, and the goal, of course, is to figure out what the other side's Scooby snack really is. All right, the third lesson I have for you from Scooby-Doo and how it relates to federal district court litigation, and it has to do with this. I think it's fair to say we can learn from Scooby that skill is not sufficient and luck is not essential. And what do I mean by that? Well, in the typical Scooby-Doo episode, the kids run around and bumble through a bunch of clues, but eventually they stumble across the key critical clue, and the mystery, as I said earlier, gets put together and solved. You've got Velma doing what we would call out here in this area the hard analytics, right? She's running the big data, crunching the numbers, figuring out the strategy. But more often than not, it's that insight coupled with some blind luck that turns the case and the kids get to resolution. Well, district court litigation is no less random than that. And I would just suggest that too few parties fully appreciate, I certainly didn't appreciate before I took this current position, how much luck plays in the ultimate outcome of your cases. Well, what do I mean by this? I think it's fair to say that most of us in this room appreciate how random juries can be, right? They are random in how they are selected. They are random in how they are seated. And they may even be random in how they deliberate, although very few of us have perfect insight into that. And yet, enough of you do mock juries, right, to know that when you observe a group of people drawn from different aspects of society working on a common problem with nothing else in common other than they all receive that summons, strange things can happen. So we all understand that juries can be entirely unpredictable, put it charitably. I think we also need to understand that judges can be entirely unpredictable, and that can also have a profound impact on the outcome of your case. Without casting too much negative light on myself and my colleagues, let me share with you a sense of how random this process can be in terms of dealing with the judge. Does anybody have a guess as to how many cases a magistrate judge or a district judge touches in a given day? What would you estimate? What would you think? 20? 5? Anybody else? 35. So I actually did a rough count last week of how many cases I touched over the course of my week. Okay? And across Monday to Friday, and dividing it by 5, on a daily basis, last week I touched 39 cases a day. Okay? Now some of them, that touch, for some of them, that touch meant simply signing a requested stipulation or on an extension, a relatively ministerial exercise. In other cases, I issued an order on summary judgment. In still other cases, I was in trial. So you have this wide range of experience on a daily or weekly basis with a given case. And yet, I think it is important, and I don't think my experience is atypical, it's important to understand that your audience in so much of the case is constantly being pulled in lots of different directions. And for those of you who do a particular area of the law, I'll just pick on my old friends for 1 minute. This is not 39 patent cases we're talking about, right? It is a securities fraud case at 11 o'clock. It's a civil rights case at 12:30. There may be detention hearings to do at 2 o'clock, and yes, even a Markman hearing to do at 4. So there is a wide range and distribution in the kinds of cases, and I would suggest that apart from all the other sources of uncertainty in dealing with the judge, the fact that your audience is constantly being pulled and pushed in lots of different directions across lots of different kinds of cases ought to inform how you approach and evaluate the risk that you're trying to figure out and bear for your clients. So yes, juries are quite unpredictable. I confess on behalf of my peers that many judges are as well. The next lesson I want to just offer up from Scooby-Doo. Teamwork is the best recipe for success. And what do I mean by this? Well, rarely in any episode of Scooby-Doo did you see one of the kids solve the entire mystery, right? There was always a clue here, a clue there, somebody putting it all together, and eventually the case being solved. Now, I think the same is as or more true in the district court litigation that we see in the San Jose courthouse anyway, and I don't think we're particularly unique. There are 94 districts in the United States. I think in more ways than not, the experience of the judges and of the courts is the same. But at least in our experience, and in my experience in particular, the fact of the matter is that in most of these cases, the focus is entirely myopic, in that parties, I think, and clients tend to look at one or two people as their key personnel in figuring out who to staff a case and how to litigate it effectively. And by and large, that key personnel tends to be the man or woman at the top, lead trial counsel. Again, perfectly rational. If the case goes to trial, if the case goes to jury verdict, the man or woman standing in front of that jury is a pretty important part of the team. But here's the thing. 97% of the intellectual property cases, anyway, in the federal district courts of the United States never see a jury, never make it to jury, are resolved either of their own accord or are resolved on some type of motion or something of that nature. In the thin sliver of cases on our docket that comprise patent cases, you see an even smaller percentage of cases making it to jury verdict. It's hard to count exactly because you have multiple defendants in related cases, but our best estimate is that in the fiscal year 2013, there were something like 70, 75 cases that went to jury verdict in the U.S. district courts of the United States. 75. Let's say it's 75 cases that go to jury verdict. That's a tiny percentage, right? It's a tiny percentage. And in those 75 cases, of course, lead trial counsel is critical. But in most of those cases, other members of the team are going to have as or more of an influence on the ultimate outcome of the case from the court's perspective. So what am I getting at here? Well, I've talked already about, I think, the significance of having someone in the settlement conferences who really understands and is focused on driving a negotiation. That I think already has been addressed enough. But in the blocking and tackling of a given case, whether it's discovery disputes, whether it's motion practice, there are a whole host of team members that I think are as or more critical to the ultimate outcome of your case. Turns out, drafting those invalidity contentions in the patent cases, pretty important, pretty important. Turns out, picking your liability expert in a trade secret dispute or a copyright infringement case, pretty important, pretty important. So I just want to urge and suggest that in the best cases that I get to work on, I see as much care and attention being paid to the selection of those individuals as I do to the others who are just as important, and perhaps even more important, but certainly not the entire certainly not entirely responsible for the successful resolution of a case. All right. Fifth and perhaps final lesson from Scooby-Doo, which is getting distracted usually leads to bad results. And what do I mean by this? Well, in the arc of the narrative of the typical Scooby-Doo episode, there is always that point where usually it's Scooby and Shaggy, but there often are others. The kids get distracted away from the task at hand, and they end up being isolated from one another. Fred urges the group to break up. Somehow they're split in a different direction, and things start to go very badly for everyone. Only when the team comes together and focuses on the specific task at hand is the problem solved. Well, in the district court litigation that I tend to see here in San Jose, we see a lot of distraction. And the problem with most technology disputes is that there's a heck of a lot to be distracted by, right? I mean, this group in this room, like many of us in the court, are by nature very curious people, right? And so the interesting can often be mistaken for the important. What do I mean by this in more detail? Well, you know, if we're talking about a patent case, I understand the statutes provide all sorts of defenses that appear to be promising and fruitful and interesting. And yet I would suggest that in this age of limited trial resources, in this age of limited judicial resources, something I talked about just a minute ago, it's just not an option to go to the judge or the jury with 20 prior art references. It's just not an option as a patentee to go to the judge or the jury with 17 claims. In a copyright case, I think it's fair to say that if you're going to lean hard on fair use as your defense, you better think strongly about whether it makes sense to couple that with 4 or 5 other defenses that may be in conflict thematically, even if not legally. There is, I think, a real struggle in managing these cases in focusing on what matters and even understanding what matters. And I understand why, because in most of the cases that we tend to see in the Northern District, your trial judge will only see your case once or perhaps twice before the actual final hearing or trial of the case. And so you have very little feedback, right, from the court on what it thinks is important or what matters. And the absence of that feedback, I think, makes the task challenging. But I would argue that it makes the task all the more important because when you have just those few minutes with the district judge, when you have just those couple of hours with the magistrate judge to try to get your case settled, picking your spots is critical, and the very best companies tend to do that over and over again. Well, I started off by talking a little bit about my Father's Day, and I mentioned that all I really wanted was a little bit of rest. I'm also familiar enough to know, with legal conferences like this to know that most people at lunch really want to do is to be able to check their BlackBerries and perhaps grab a second drink. So I don't want to overstay my welcome. But Ian did mention I am eager to answer whatever questions I can about the work that we do in the Northern District and the work and the cases that I see here. So if any of you have any questions, I'm here and I'm an open book. So thank you for this opportunity and looking forward to answering your questions. Anyone? We have one volunteer.
Did you know that a Scooby snack is a reference to drugs?
I can either confirm or deny my knowledge of that reference. The fact that Scoob and Shag were always suffering from the munchies is also something I really just don't know anything about. What else can I tell you?
Do you have any thoughts or insights on class actions? Because I appreciate your comments and settlement, which I've worked in a lot of civil cases for a long time. Class actions tend to not be about the merits anymore. And do you have any insights or thoughts on where that's going?
Sure. So we tend to see class actions in the Northern District in a couple of different ways, right? So the good old-fashioned product class action case is still there, although I think, is rarer than it was 10 years ago. The wage and hour class actions are still there, although I think the state of the law in the California courts has had an impact on those. Where we tend to see a lot of class actions, especially in San Jose and in the Northern District, is in the privacy context, and oddly enough in the food litigations. Are you all familiar with that? You probably aren't. The Northern District of California has become a real center for litigation over labeling on foods and whether those labels are mislabeled or misrepresenting themselves in some way. To answer your question, though, about class actions generally, I think merits have become less significant in large part because so few of these cases make it past class cert, right? Yeah, so for the IP lawyers in the room, what Markman is to a patent case, the cert hearing is to a class case. At least that's how this old IP lawyer tends to think of it. And, I think part of the challenge in the class action cases is that there is, particularly when we're talking about the privacy cases, there is so little case law, really, if you think about it, about issues of standing, about issues of the application of the Wiretap Act, about issues regarding the CLRA, and so on and so forth, that whatever merits discussions we tend to have in settlement conferences tends to devolve into a sort of an academic discussion about what could be or should be or might be. So what does that leave you in the typical mediation to talk about? Well, you can talk about the cost of litigation. You can talk about the odds of certification, right? Are the 23A factors going to be met, and so on and so forth. So I tend to agree with you that there's very little discussion of the merits, and I don't think that's going to change anytime soon until we see more of these cases making it past class cert and getting to trial, or at least getting to summary judgment so that there are real decisions out there on the merits that will give parties something more concrete to talk about. Other questions? Yeah, sure.
Good afternoon, Judge Grewal. So you recently issued an order regarding a search warrant where you said that the big data companies, while they're out in public talking about protection of people's information, didn't actually put up much resistance when it came to these search warrants being executed. And Mike, I was wondering, first of all, maybe you could elaborate on that circumstance or what that, maybe just it's the narrow order itself. But do you think there's a role for maybe a public ombudsman or something to actually advocate on behalf of privacy interests in those conferences where you have the FBI or these agencies in seeking data?
Well, obviously I can't talk about the specific case, but I can speak more generally to the issue. I think the big problem right now in dealing with this issue is that most of us don't know what we don't know. That is, there's very little transparency around the process for securing search warrant applications. Right, so the public, rightfully, I think rightly so, I should say, has seized upon certain activities of the NSA, and if they're listening, I love you, NSA. But it's been curious to me as one of many magistrate judges all across the country that the bulk of what we see and deal with on a daily basis has nothing to do with the NSA. It's the FBI, it's the DEA, it's other agencies looking for evidence in these various locations. My concern is that not enough people understand, first of all, what's happening, and even fewer understand what responsibility each of the players in this little drama have for making sure that we get this right. So what am I talking about? Well, first of all, very few judges write opinions about what they have done when presented with an application for a search warrant, right? Some of my colleagues elsewhere in the country, I think, have been are to be commended for taking the lead in trying to change that culture. And it's the easiest thing for a magistrate judge to do with 10,000 other things to worry about is to simply say yes or no and to move on. I have attempted to, write where I can on that subject so that at least, whether I'm right or wrong, people know what we're seeing and what I'm doing, and hopefully, others will take up that mantle as well. As far as what companies are or are not doing, again, all I can say is I can only speak from my own experience, and I have yet to see, and I wasn't just picking on one company, I have yet to see any company come to my court and challenge a warrant that's been issued because of breadth or other concerns. And there may be darn good reasons for that. That's not for me to say. I just think it's important to get the record established so that we can have a meaningful discussion around that. And I, for one, would love to see, I would love to see much more dialogue around that because I'm not always confident I'm getting it right. And I have to say, as an old civil litigator doing IP work, the scariest thing for me coming to this job 3 years ago was how much of it happens in chambers ex parte. And there is a wonderful discipline that comes from having an adversarial process to get at an answer, right? When you don't have that other side there, when there's no defense lawyer pushing back on me when I have to decide whether a warrant is justified or whether it's properly scoped, it puts a lot of pressure I welcome, but pressure nonetheless, to make these calls without having a complete picture of what's going on. And I just think, the more we can provide transparency around that, the better. And that's what I've been trying to do. Other questions? Yes, sir. Oh, I can encourage, yeah. To answer your last question, sure. I have ordered parties to send different people if I thought it would be productive. At the same time, I'm a big believer in the notion that parties and lawyers settle cases. Judges help make it happen in some instances, but we're not the center of the world in that process. We shouldn't be, at least that's my feeling. I rarely see divided responsibility. I rarely see a different, forget about team, I'm talking about team member added to that process. Where I have seen it, and I have seen it on occasion, it has been tremendously effective. But I also recognize that not every case has the budget for that. Not every case has the exposure to justify that. I just think, again, if it's on the checklist and there are good reasons not to do it, I have no complaints. But when I talk to clients in these conferences and I ask them, how did you decide who was coming this morning? That's often my first question. 9 times out of 10, I get silence. And that gives me some pause. Other questions? Yes?
Yeah, Judge Grewal, a few judges now in the Northern District now require that claim construction be conducted in conjunction with summary judgment motions. Do you see that expanding, and what are your own personal views?
Well, it's interesting. So I was kind of raised and brought up with the notion that the earlier the markman, the better. So in my own cases, I can't think of a single patent case that I've presided over or tried where I did not have markman several months before the close of discovery, and certainly several months before the final pretrial conference. I will say your observations, I think, are on that there is a bit of a counter trend right now in our district. Judges who for years have been doing earlier markmans are now deferring them until summary judgment. It's kind of curious because the wind is blowing the other way in places like Delaware, right? So there is, I think, nationally a conversation happening which suggests that more and more judges are thinking about doing markman sooner rather than later. My reason for doing markman earlier, and I do talk to my colleagues. We do have coffee. We share ideas. When I've had the opportunity to do that, what I've urged is this. I find it very hard to settle a case before a markman. Very hard. There are certain cases it can settle, but most cases can't until you have at least some sense of the claim scope. And if you defer markman until the very end of the case, my feeling is that you put off that conversation. You also make expert discovery much more expensive, right? It's always fun having your expert guess as to the scope of the claim and offering an opinion on validity and so forth. So I'm a big believer in doing it earlier, but I will say that I seem to be, at least locally, part of a minority. Other questions? Yeah.
I understand you, right? Using company data warrants. How you just go for?
Not typically. Not typically. Yeah, no. Well, and it's important because it's important to understand the context for this, because one reason is, God forbid I got it right and I issued a properly scoped warrant that requires the production of the evidence in the email account or on the social network file. But my only thought is that that decision is being made in a very narrow context, right? I mean, it is literally a judge. I mean, just let me paint a picture for you for those of you who haven't been down to our glamorous courthouse in San Jose. By the way, we do not get salmon and quinoa for lunch the way you guys do. I mean, it is, on the 4th floor, on the end, it sits my chambers. And in my chambers, I have two fabulous law clerks. But most of what they do is they focus on civil cases because you all are filing so many motions and bringing so many cases to trial that we have to keep up with that part of the docket. In 98% of the cases I'm working on, I am the only one who's looking at the application for the search warrant. In 98% of the cases I work on, I'm the only one who's reviewing that agent's affidavit to make sure that what probable cause exists is properly scoped to what's being asked for. And in 98% of the cases, I will tell you, where I find probable cause is usually not the issue. It's not the issue. It's scope. It's particularity, right? I have rejected more than my share of warrants for lack of probable cause. I don't want to suggest otherwise. But in most instances, the issue is, fine, you have probable cause to look in this individual's Hotmail account. Fine, you have probable cause to look at this person's Yahoo Mail account. But do you have probable cause to go back 15 years? Do you have probable cause to ask for anything within a given period of time? Do you have probable cause to take anything that you see? Because under the plain view doctrine, that's what generally happens. And my only concern is that if those are the right answers, terrific. So if that's the law, I will apply it. I just think the system would benefit from more robust input from the stakeholders who are in a position to do it. Your typical account holder sitting in Dubuque or sitting in London or sitting in Palo Alto doesn't have the resources to push back and to ask hard questions. I would just suggest to some, perhaps who are even in the room, that the entities with those resources, I think, have a unique role to play and could perform a valuable public service by stepping up in the way that many of their public statements have suggested they're willing to do. Other questions? Easy crowd. Anything else? All right. Well, I thank you for this opportunity.